Hello, I'm Philip Rawlings, the Roygood Professor of Commercial Law at the Centre for Commercial Law Studies, Queen Mary University of London. I'm also convener for the Law of International Finance, Syndicated Loans, on the International Programme of the University of London. This course is about an important way in which large companies raise large amounts of money. Let's say a car maker wants to build a new factory at a cost of £1 billion. How does it raise the money? It could go to its bank, but the bank might be reluctant to lend such an enormous sum. One solution is to persuade several banks, a syndicate, each to lend part of the money. This is an enormous market. Across the world in 2015, borrowing through syndicated loans reached $4.7 trillion. It's also an international market. And because of its global importance as a finance centre, London is one of the main places where such deals are arranged. Such deals raise a lot of interesting legal issues, the first of which is what legal system applies to the deal. These deals typically involve players in different countries. For example, the syndicate might comprise a US bank, a French bank, a British bank, a German bank, and a Japanese bank. The borrower might be a Norwegian company that wants to drill for oil in Indonesia. And the contracts might be negotiated and signed in London. Well, we could just state in our contract that a particular legal system applies, so let's choose English law. But how do we know if the Norwegian company has the contractual capacity to enter this contract? Do we assess this by English law or by Norwegian company law? And the loan is secured on the Indonesian oil wells. What powers do the lenders have over those assets? Are these determined by Indonesian law or Norwegian law or English law? Another problem is the nature of the relationship between the various parties. Let's say that in our example, each of the 5 banks promises to lend £100 million. What if one bank can't comply because it's become insolvent? Are the other banks obliged to step in and make up the difference? Some other issues arise. Syndicated loans often last for several years, so lenders need some reassurance about the continued financial health of the borrower. And if something goes wrong, they need to know they can act to protect their investment. We can, of course, take security over the borrower's assets. This would give us the right to sell them, but that's a drastic solution. And anyway, the security may not be as valuable as initially thought, particularly if we have to sell it in a hurry. Much better to prevent a crisis from happening, if possible. But this isn't straightforward. We could put in lots of controls. So, we can have terms that require the lender to keep its business within certain financial limits and that restrict its ability to dispose of assets. But we don't want to impose too many restrictions because they might obstruct the borrower's ability to do business. What terms should be included? What problems arise in drafting these terms? And how are they resolved? Of the many other issues covered by this course, I'll mention just one. These loans may last for several years, and for reasons we will discuss, banks don't necessarily wish to retain their involvement in the loan. So there's an important market in loan participations, which means that the transfer of loans is an important area of law and practice. Again, there are difficulties which as lawyers we need to help solve. For example, the borrower may not want the original lenders to sell on their participations because it enjoys a good relationship with the lenders, which could be important if it encounters difficulties in complying with the terms of the agreement. The borrower may therefore insert into the original contract a prohibition on transfer. Now, this is something many borrowers are able to do because they're far more powerful than you or I when negotiating with banks. But how effective is a restriction on transfer? Can the lenders get round it? The brief answer is they can, and the longer answer, which is discussed in the course, shows the inventiveness of the market in finding solutions. Surprisingly, for an area of law that involves trillions of pounds, There is relatively little hard law in the sense of cases or legislation. This makes the course particularly exciting because we need to think about how to deal with problems. So lots of opportunities for imagination and innovation. I should add that although this course focuses on syndicated loans, many of the terms we'll discuss and the issues that arise can be found in other areas of international finance, such as bonds, securitization, and project finance. Finally, knowledge of English contract law is not necessary for this course. You will learn all you need to know as you progress.